Actually, what's kind of important in my mind is this deal with these cases. Much like Mr. Gould, I spent a lot of time looking at the cases that you cited, and I can't find that these cases exist. Where'd you get these cases that you cited?
Google and a lot of AI research.
You used AI, didn't you?
I will freely admit it for the research. I'm not trying to waste your time.
You didn't check and make sure that those are real cases, did you?
Not on every one of them, unfortunately.
In a municipal courtroom in Wausau, Michigan, Kendall Meade is representing himself. He's challenging the city's ban on domestic fowl under Wausau City Code Section 5.04. The ordinance prohibits keeping any animal or domestic fowl within city limits except indoor household pets. Meade filed his own legal brief, citing case after case to support his argument. But when the city attorney went to verify those citations, he couldn't find them because they were fabricated.
Kendall Meade versus the city of Wausau. Are you Mr. Meade?
Yes, sir.
Yeah, have a seat, please. And then we have Mr. Scott Gould here. He's the city attorney for Wausau. This is the city of Wausau's motion for summary disposition. I have read the motion and I have read the response. Mr. Gould, are you ready with your argument?
I am, Your Honor.
All right, you may step up and proceed.
Before I get into the actual legal argument, there's a few preliminary matters that I think have to be brought before this court, and they are very much related to this very summary disposition. City of Wausau filed a motion for summary disposition. Mr. Meade responded. Having researched Mr. Meade's answer to the summary disposition, it came to light after going in circles for some time that the case law cited, the opinions apparently rendered by some court, are in fact fictitious. I have reason to believe that AI probably helped Mr. Meade in this, and because I went round and round, second guessing myself about these case laws, about whether there were courts out there having these different opinions about municipal law, I finally had to reach out to a colleague who's also a municipal attorney, Justin English. I had him review the same cases, and with those cases, I have an affidavit from his office whereby he himself, using different tools of research than which that I have used, saying that these cases are in fact fictitious. I have an affidavit here by Mr. English, if the court's so inclined to.
Why didn't you file a reply and include it in a reply, Mr. Gould?
Well, Your Honor, I will say that as I kept researching this matter, I for lack of my own confidence, I thought I was missing something. I kept chasing ghosts out there. And
that's why they call them hallucinations.
Yeah.
Right? Fake cases, fake AI cases are called hallucinations.
Oh, actual name? Okay.
Yeah, that's what they call them. They call them hallucinations. Oh, I'm well aware. I've done the same thing you have.
And it really comes down to really that, Your Honor. This is the first encounter that I have where I've had opposing counsel rely on that platform so much without verifying in some other fashion. And that is a problem that I incurred. This is the first time I've experienced that. That's the reason why I didn't file that in advance.
It's pretty unsettling, isn't it?
It is. It's concerning, and Wausau's my hometown, and it bothers me that, you know, this is serious stuff. This is an expense to the taxpayers. I mean, I'm not trying to talk myself out of a job, but making allegations and then coming to this court with fictitious court names and opinions is dangerous in a lot of ways. And it's concerning. So it really came down to I had to reach out to somebody else, make sure I wasn't losing my mind, so to say.
Well, why don't we get through the argument? I'm well aware of the hallucinations, Mr. Gould, and I'll address those directly with Mr. Meade when it's his turn to speak.
The city itself is aware that there's no section 5.10 in the Wausau City Code, nor is there any special permit scheme for chickens. The plaintiff is asking this court to strike down a licensing system that does not even exist. Wausau does have an ordinance prohibiting fowl, chickens, the raising thereof inside the city. That section is 5.4. And it clearly states that no person shall keep or house any animal or domestic fowl within the city except for indoor household pets. The plaintiff, when you look at his answer, it's pretty forthcoming. The plaintiff states in the statement of facts, provides that the city, with all the evidence needed for summary disposition, in that he admits to acquiring laying hens, that's not disputed. He admits to housing them in an outdoor predator-proof coop. He admits to allowing them to free-range access on his residential yard. And it doesn't matter how peaceful the hens are or hygienic the hens may be. It's still a violation. The housing in that area is very dense. In fact, the generally accepted agricultural management practices sets out setbacks for any kind of livestock in highly dense residential areas. And that setback is 250 feet to the nearest non-agricultural neighbor. Well, those lots inside that area, and I have a map that the court's so inclined to see how dense that area is, the lots themselves can't be more than 110 feet each. And so there's no way that even if you gave him the benefit of the doubt of being a farmer and you went and looked at the generally accepted agricultural management practices, he would even qualify by state's standards. Therefore, it's my opinion that the Right to Farm Act is not even applicable in this scenario. And that's what he's obligated to do. To date, I don't have a witness list, I don't have exhibits, I don't have anything that I can rely on for him to tell me that he's in fact compliant with Michigan's agricultural standards. I don't have anything that suggests or shows me that he's in fact a farmer. We're on the cusp of trial now at this point, and I don't believe he can even raise this matter now.
With the city's argument on the table, Judge Stewart turns to Meade for his response.
I moved into that house in Wausau without even properly realizing that it was a separate city than Corunna. I'm originally from East Lansing, but like I lived outside the state for the majority of my life and moved back in 2018 to northern, the Traverse area. But yeah, I purchased what I thought was legal chickens, and I maintained what I thought was legal compliance, which Mr. Gould here has, found reference to in my documents. I thought I was maintaining compliance for what were the laws in Corunna. When informed that I was no longer in compliance, I also filed an objection here after being referred around in my attempt. And I mentioned the RTFA partially in reference to a business that I've formed in February of 2025. So it's a young enough business that I've never actually filed tax returns. A lot of the paperwork that has been requested by Mr. Gould does not yet properly exist. So, I mean, there's been some problems for ability to serve responses in terms of that. I've attended mediation. I'm jumping around in the story here.
I just really need you to respond to Mr. Gould's motion. This is your time to argue, so I just really want you to stick with the points that he made.
Okay, so the issues of material fact, that's probably the most important one to go with.
Under Michigan court rules, when you sign a document filed with the court, you're making a legal certification. You're telling the judge that, to the best of your knowledge, the contents are grounded in fact and warranted by existing law. It's not a formality, it's a promise that carries real consequences. And Kendall Meade signed his brief. Since 2023, courts worldwide have tracked over 1,000 cases involving AI-generated hallucinations in legal filings. Attorneys have been fined, suspended, and referred to their state bars for citing cases that don't exist.
That's very bad, Mr. Meade. Because when you cite a case that isn't good law, you're misrepresenting the law not only to Mr. Gould but to the court.
Understood.
When you cite a case, when you cite a case, you're telling the world, look, this is the law that you need to follow, Judge Stewart. This is what I'm representing. And then when it's not, it's a misrepresentation.
It's only the misrepresentation that I was under the impression of also.
Oh, I don't understand that.
I was led to the impression that was, I should have checked. I freely admit, I apologize for that.
Okay.
I did my best to check on as many of those as I could, but my time is limited.
So because your time is limited, Mr. Gould and then this court had spent a lot of time trying to verify your cases.
So
whose time is limited, yours or ours? I mean, we spent a lot of time looking at the 5 cases that you cited, and you said you didn't have time to check them, to verify them, right?
I'm not saying that at all.
That's what you said. You said my time was limited. That's kind of disrespectful. Your time was limited, so you didn't check your cites and shifted the burden to the court and to Mr. Gould's office to determine the accuracy of your cites.
It's very disrespectful of me to do that, but I assure you that was not my intention. My intention was to relay that what I had assumed was accurate information on the basis of the amount of checking that I had done of the citations previous to that. So it's not that every response from an artificial intelligence agent is completely hallucination. There's a mixture of like accurate information, real citations.
And if you know that, that's even more troubling to me. You know that there's hallucinations out there and you didn't double check your cites.
Your Honor, for these proceedings, I'm somewhat overcome by the requirements of the paperwork and the amount of research that has been required.
No, you said you intentionally included a legal cite, a case cite, that you knew might have been a hallucination.
No, sir.
You just said, I know that some in AI, some of it's accurate, some of it's hallucinations.
Allow me to clarify.
But that's what you said.
I'm aware that it's possible that they could get through, but my intention...
So knowing that, you didn't check and make sure the site was legit?
I thought I had checked every reference that had gotten through to submissions to the
So
court.
you just happened to not check the 5 cases that you cited?
Your Honor, that was 5 cases in a volume of probably 30 or 40 cases that I was also researching.
But you cited 1, 2, 3, 4. You cited 4 cases at the beginning of your answer, and you laid them all out in the middle in bullet points. And you said, my time is limited. I checked some of them, but yet you led your brief with these 5 cases.
Your Honor, this is my first ever legal case. I apologize.
This doesn't have anything to do with the legal case. This is lying. This doesn't have anything to do with being a lawyer or being a non-lawyer. This is putting a case out there for the court and representing to the court that it's true and it's accurate. That has nothing to do with being a lawyer.
Your Honor, I put nothing in there that I knew to be
But
misrepresentation.
you did, because you just said sometimes that AI can give you inaccurate results. You're just digging yourself in a hole. You better continue with your argument then.
Accounting for the presence of what are miscitations in my argument still stands that the law as enacted by the city of Wausau is ultra vires in 2 counts. On the first count, it's ultra vires in trying to ban chickens on the basis of a law that makes no concession to any form of regulation of chicken ownership. I have a copy of this law here if you'd like to see it, but I can read it in its entirety.
I'm not asking, you're not reading that in its entirety.
Okay.
It's surprising in this case because plaintiff's brief contains a fair bit of material that really demands a reply. It looks like Mr. Gould is working on it and has actually had another attorney assisting him with it. Much of the case law in plaintiff's brief is fabricated, or what we refer to as an AI hallucination. Plaintiff cites 4 cases on the second page of his brief and provides what he claims to be direct quotes from those cases. First, 313 Mishap 104. He claims it's a 2015 case. Plaintiff identifies this as Bingham Farms versus Lawrence. But if you go to that site, it actually takes you to MEEMIC versus Michigan Millers Mutual Insurance. Plaintiff specifically cited at page 116 of that opinion, which is actually from a case called Chiropractors Rehabilitation Group versus State Farm. And there actually is, there is a Bingham Farms. We found it, and that case didn't involve chickens, but it involved sewers and waters, and municipalities arguing over access to sewers and waters. Plaintiff's next cites to a case that he calls Hatfield versus Township of Heartland, a 221 case identified as a Court of Appeals docket number 354103. That docket number points to a case called In Re BS. I'm not pointing out the irony of this name in the bench opinion, but that's an adoption case, and it's unsurprisingly silent on the issue of keeping of chickens. The next case cited by plaintiff, Farms Not Factories versus the City of Lansing. Court of Appeals docket 367891. But that docket number belongs to a case called Henry H. McClinton, another adoption matter. Here's another case, Adams versus City of Battle Creek. For this case, plaintiff provided a bogus Westlaw citation that doesn't return any case at all. In fact, Westlaw citations are 7-digit citation numbers, and this was 1, 2, 3, 4, 5, 6, 7. The odds of a case with a citation of 1, 2, 3, 4, 5, 6, 7 is 1 in millions. I've never seen in my career as a judge and attorney seen more than 3 sequential numbers in a case cite, let alone 7. The court found a 2001 wiretapping case by that name, but it has no bearing on this matter. He also cites to Williamstown versus Sandalwood Ranch, 325 Mishap 541. That's a 2018 case. The citation checks out, but that case involves latches applied against a plaintiff municipality. Defendant corporation asserted affirmative defense of latches, and the Court of Appeals held that the corporation failed to produce evidence to substantiate the defense. Next, plaintiff cites 478 Mish 908, claiming it is Papadelis, Papadelis versus City of Troy. That citation could point to short orders on 2 other cases, neither of which are consistent with plaintiff's brief. The reason why I spent so much time talking about these hallucinations is that I spent a lot of time trying to hunt down the law. Apparently, Mr. Gould did too. It's incredibly inconvenient when the attorneys and judges and court staff are trying to make sure we get it right by finding the correct law. And this wasn't that. And by signing your answer to the motion, Mr. Meade, you certified that your response was warranted by existing law, pursuant to MCR 1.109E5. The court isn't going to sanction you today. The court is just going to admonish you for misrepresenting the law. And I'll leave the issue of attorney fees to Mr. Gould. If he wants to file a separate motion for attorney fees and lay out what you've done and what your position is and based on the law, I'll consider it, but I'm just not going to do it today. But what the court is going to do is strike the plaintiff's answer in the offending brief. And I think that's a fair remedy. I'm just striking it. That means that the court will treat the motion as though no response has been filed. That said, even if the court does consider the brief, even if it did, the plaintiff would not prevail at the motion hearing. Plaintiff argues that genuine issues of material fact preclude granting the motion, but plaintiff didn't attach any documentary evidence in support of his position, meaning he can't and didn't show a genuine issue for trial. Plaintiff's response also did not address the C8 components of defendant's motion. So that aspect of the motion is truly unopposed, at least on the papers. So for all those reasons, the motion for summary disposition based on C8 and C10 is granted, and this case is dismissed. Mr. Gould, please prepare an order, and I'll leave it to you if you want a remedy on the AI.
I appreciate it, Your Honor. Thank you.
Thank you all. We're in recess.
What makes this case different from most AI hallucination stories isn't that Meade used artificial intelligence. It's that when confronted, he told the judge he already knew the tool could fabricate information and submitted his brief anyway. The technology isn't the problem. The problem is what happens when someone stops checking. What do you think of Judge Stewart's ruling? Drop yours in the comments below. Check out this next case, which we think you'll find interesting.